Can I choose my own attorney in guardianship? Have you ever wondered if you can select your own attorney during a guardianship process? This is a vital question for many individuals facing guardianship issues. Generally, the person involved in a guardianship proceeding, often referred to as the ward, does have the right to choose and hire their own attorney. This right is essential to ensure that the ward has independent legal representation. It is especially important when the ward's interests may differ from those of the guardian or the court. In the context of elder law and guardianship, the ability to select an attorney is a significant protection of legal rights. While a guardian is appointed to make decisions on behalf of the ward does not lose all legal rights. This includes the right to have legal counsel. The attorney chosen by the ward serves as a strong advocate for the ward's wishes, rather than simply representing the interests of the guardian or the court. However, there can be complications when it comes to exercising this right. Sometimes, the court or the guardian may have concerns about the ward's ability to retain counsel. For instance, a probate judge might question whether the ward is competent enough to enter into a retainer agreement or to direct their own legal representation. In such situations, the court may requiring approval or oversight regarding the ward's choice of attorney or the terms of representation. It is also important to note that, if the ward's interests conflict with those of the guardian, the ward should have the chance to prove their competence to select counsel. They should also be able to challenge the guardianship itself. This is particularly relevant if the ward's condition has improved since the guardianship was established. Courts have ruled that guardianship is not permanent. Wards have the right to petition for removal or modification of guardianship with the help of an attorney they choose. From a practical standpoint, being able to choose one's own attorney allows the ward to work with a lawyer they trust. This is often someone who has experience in elder law, estate law, or guardianship matters. Having a trusted attorney can lead to better communication and help protect the ward's rights. It also supports efforts to restore autonomy or modify guardianship arrangements when appropriate. To summarize, the ward generally has the right to hire and be represented by their own attorney in guardianship proceedings. The attorney's role is to advocate for the ward's expressed wishes. Courts may oversee or approve the ward's choice of counsel if there are concerns about capacity. Wards have the right to challenge guardianship and seek its modification or termination, often requiring independent legal counsel. Choosing a knowledgeable elder law attorney can be vital in protecting the ward's rights and interests throughout the guardianship process.